I just wanted to remind my colleague that he needed to emphasize that most fundamental matter called costs. We need costs on behalf of the Deputy President for all these bad things that have been done to him and to us. Thank you very much, my lords.
Well, that concludes the highlighting on behalf of the first petitioner. We thank you.
Thank you. I see Dr. Gada standing up.
Yes, Your Lordship.
You said you wanted 2 hours, huh?
No, 2 hours. We will be done in an hour less. Myself and my brother Sakim.
Hello?
We come through.
Well, Lord, we are yet to address the court for the 44th to 49th.
I'm also present on behalf of the second petitioner. So I don't know if I will be able to address today or the other day. Oh, my name is Teresia Wanjiru Kimoto of Tess Kimoto and Company Advocates Kerugoya.
Yes, my lords, if I may, just for a minute.
Yes.
I'm not objecting to Tess. My lord, in terms of equality of arms, I am concerned that the petitioners, having had 5 hours, and the other parties having the possibility of attacking another 1 hour or 2 hours, would then mean the respondent then would have, in terms of equality of arms, we then need the same amount of time in responding. And you had given 6 hours previously. So perhaps I suggest that Evans Ogada, the professor, together with the other petitioners, then share the 1 hour so that we are equal, so that we don't go outside the 6 hours. Tess can take 20 minutes so that we...
Why me 20
Well, I think my learned friend, Professor Tom Ojienda, is being anticipatory. Let him wait and see perhaps how long we take. Then he can say at that time how much time he wants, rather than trying to, put the court in some straitjacket. We are very grateful. Those appearing for the first respondent, but I do plead that the other counsel appearing for the other petitioners have their day in court.
We are in court.
Yes.
We are in court. They are having their day.
They have their day.
Yes.
They have their day in court.
Yes.
Because what this honorable court will ultimately say, either way, is going to apply in future.
I think the only issue we need to address is how much time do we give them, and I think we should appreciate that we don't have all the time. So let us plan to share a maximum of 1.5 hours.
Your Lordship, I'm sorry, but I'm constrained to object to that approach. When we had the hearing for the conservatory orders, we restrained ourselves and took our and allowed the court to limit our time. But I think for the petition, let us have sufficient time to ventilate on all the issues. We shall take the least amount of time possible. But if you say 1.5 hours, and Dr. Ogada is coming up, I do not know how much time you will have to for the rest of us.
I think we are wasting time. Let's proceed. We'll see how far we'll go.
Good afternoon, Your Lordship, Your Ladyship. I appear alongside my brother, Mr. Sakimpa. We appear on behalf of the 4th to the 8th petitioners. Ab initio, we will be relying on the following documents. We will be relying on the petition dated 18th October 2024, the affidavits in support sworn on 18th October, the written submissions dated 16th January 2026, the list and bundle of authorities dated 16th January 2026, the further list of authorities that dated 25th April 2026. All power has a limit. All power has a limit. Certain values in the Constitution have been designated as foundational to our democracy. This in turn means that as pillar stones of this democracy, they must be observed scrupulously. If these values are not observed and their precepts are not carried out conscientiously, we have a recipe for constitutional crisis of great magnitude. In a state predicated on a desire to maintain the rule of law, it is imperative that one and all should be driven by a moral obligation to ensure the continued survival of our democracy. That is a paragraph from Nyathi versus member of the Executive Council for the Department of Health, Gauteng, and another 2008, Madala J at paragraph 80. It's in our list of authorities supplied, dated 25th of April 2026. My good friend, Elisha Ongoya, wandered in the morning, and I joined him in the wandering. Which way, Kenya? What is the state of our morality in terms of our constitution? We have provided a case, and that case will form my next line of submission, the case of EFF, Economic Freedom Fighters versus National Assembly, 2018 South African Constitutional Court. Which way for Kenya? The first petitioner has gone through what happened in terms of the process. It paints to us a very worrying state in terms of the health of the democracy that we have in this country called Kenya. This is a clawback in terms of the Constitution and the state of our democracy, culminating into the Constitution 2010 that was characterized by huge cost for the ordinary Kenyans. People shed blood, people were killed, and people died. We should not lose focus of that. And that state of affairs painted by the first petitioner leads me to pose this question to the court. Did we need specialized rules and procedures for this process of investigations and hearings to be established before the process commenced? Did we need specialized rules and procedures before the process of impeachment investigations and hearings commenced? That is a question, your lordships, your ladyship, this court must answer. And like my elder senior counsel, Elisha Ongoya, I'm relishing to read the answer to that question from this court. On our part, we respond in the affirmative. Yes, we must, and we needed to have specialized rules before the impeachment began, either in form of a specialized code, or it ought to have been mutually agreed between the parties. Parliament ought to have sat down with the Deputy President and agreed on the rules of procedure, or else we should have had a specialized code. For the following reasons. Number one, protection of constitutionalism and the rule of law. Pre-established rules ensure the impeachment follows constitutional norms rather than political convenience or sudden improvisation. The Speaker extends it to Saturday. Parliament says no. We will do as we wish. Error. Kosa kubwa. Secondly, prevents abuse of power and political witch hunts. Clear procedures make it harder to weaponize impeachment and partisan revenge for short-term political gain. Number 3, guarantees of fairness and due process. The office holder facing impeachment deserves predictable procedures, notice of charges, a right to respond, and an impartial hearing. Number 4, enhances legitimacy and public confidence. When procedures exist beforehand, the public is more likely to trust the outcome as lawful and not pre-engineered. Public trust, public confidence. Next, it ensures institutional consistency. Preset rules prevent changing procedures mid-process to suit the circumstances or the person under investigation. We are giving you, was it 10 days? Then midstream, we are going to continue, irrespective of whether you are sick or not. Rule of law questions. Can we operate a serious constitutional interrogation such as an impeachment in that manner? No, we say. Promotes separation of powers. Structured procedures reduce institutional conflict by clarifying the roles of Parliament